Okay, I think we're ready. We'll call the meeting to order. The chairman has a bill to present, so I'll be heading the meeting, Vice Chairman Knapp. Could you please take the roll?
Okay, Representative Chadwick.
Here.
Representative Haroldson.
Here.
Representative Harshman.
Excused.
Representative Knapp.
Here.
Representative Newsom.
Here.
Representative Ottman.
Here.
Representative Wiley.
Here.
Representative Yin.
Excused.
And Chairman Olson.
Excused. All right, welcome everybody. Today we have two bills that we're covering. One is, we'll start with House Bill 38, and I will call the presenter of this bill. Yeah. We'll hear from the Secretary's office first.
Yes, thank you. Thank you, Mr. Chairman. I'm Chuck Gray. I'm joined here by Joe Rubino, our policy director and counsel to my right. As I have said throughout the 2023 interim and including in our original request for the committee to consider this bill, I'm in complete and total support of imposing a durational residency requirement to vote in Wyoming. At present, Wyoming remains one of a minority of states without some sort of durational residency requirement, and effectuating appropriate requirements like a residency requirement in addition to other measures to strengthen our residency requirements help us to ensure integrity in our elections by making sure Wyomingites and only Wyomingites are voting in our elections. I wanted to note a few things concerning House Bill 38 as introduced, our plans to dutifully implement if passed and signed into law, and a few technical amendments we will be talking about and potentially and also requesting. First, again, I am in complete and total support of a durational residency requirement. I believe it is essential to ensure that Wyoming has safeguards in place to strengthen Wyoming's residency requirement and ensure that there is a durational aspect to ensure Wyoming's elections are decided by Wyomingites. But for the reasons we already set forth during the 2023 interim meetings, I believe it fits squarely in line with constitutional requirements and federal law. I want to note our discussions throughout the interim concerning the interplay of the bill and that of the Voting Rights Act. The bill was originally drafted and imposed a 30-day durational residency requirement, largely mirroring that of Idaho, which is also exempt from the National Voter Registration Act. This applied to all elections, including those for president and vice president. For many of the reasons we set forth during the interim, I believe this bill satisfied federal requirements as it was written to apply to all elections. During the October Joint Corporations meeting, the bill was amended to provide an exception for otherwise qualified electors who do not meet the durational residency requirement to cast a ballot in Wyoming for president and vice president. As I said during the interim, I do not believe this amendment was necessary, but it does add additional burdens on our local election officials, which I want to bring to the committee's attention, and some things that have further come out that have been revealed since that amendment was done there during the meeting in October. It should be noted that the exception to the durational residency requirement for president and vice president does not eliminate the need for county clerks to verify that the elector meets other eligibility requirements, such as age, felony status, deceased record check, citizenship status, duplicate record check, etc. This is commonly referred to as a HAVA check. The HAVA check is currently accomplished in WyoReg and WyoReg ePollbook, which is our voter registration system, by completing a registration of the voter in the system. If the bill is not amended, the practical effect would be that election administrators would need to complete the HAVA check through existing systems while also not registering the voter. I will again suggest to the committee that in order to avoid this additional and unnecessary burden, which I believe the clerks are going to elaborate on, the committee amend House Bill 38 by deleting the language of the exception on page 4, lines 9 through 14. I also want to note another small change. Currently, House Bill 38 contains an immediate effective date, as the bill would require a slight change to Wyoming's voter registry system, necessitating the technology change noted above. I would ask that the bill be amended such that the bill is effective July 1st, 2024. This will ensure it is effective prior to the beginning of the 28-day early voting period for the 2024 election. Now, Vice Chairman Knapp, Chairman Olson texted me last night. He wanted to talk a little bit about how the rule is distinct, the rule we're doing from House Bill 38, because they are entirely different in addressing residency, a key priority of our administration. Would you want me to delve into that a little bit? The chairman did request that over text.
Please, Mr. Secretary.
Thank you, Mr. Chairman. I also want to touch on the proof of residency rule and how it is a different angle of attack to address our administration's priority of addressing residency for voting. Again, the durational residency requirement, which is before you today, and this proposed rulemaking are wholly distinct from one another and address the overall issue of residency and durational residency from two different angles of attack. Our office's rulemaking concerns providing proof of Wyoming residency upon registration, regardless of any durational attestation, which is what the bill delves into. And it's proof of being a bona fide resident, which is already in statute and something that somebody attests to when they register to vote, as opposed to attesting to meeting the durational aspect, which is what the new statutory requirement would require. In fact, this rulemaking was spurred in part by a collaborative process and concerns brought by the county clerks in numerous discussions before the Joint Corporations Committee as House Bill 38 was debated during the interim. In August, when the formal bill draft for the durational residency requirement was first taken up, the county clerks pointed out something. It was in both their public testimony and their public written memo presented to the committee. In that public testimony, they highlighted, and I'll quote, "I do want to highlight on page 2, referring to the memo, that we say, we believe that these are two distinct matters to be considered, but admit that without addressing the broader issue of residency, a durational standard will have the same enforcement effect as the current residency standard," unquote. What they're referring to, and the memo further delves into that, is that without proof of residency to address the issue, proof of being a bona fide resident to address the issue, there is also a huge hole in our state's approach to residency. In fact, the memo dated August 22nd states on page 2 that they will, quote, "provide information about what other states require as proof that a potential voter has fulfilled their durational residency requirement," unquote, and they delve into that further. And that was really inspiration for us beginning this process. After digesting the county clerk's memo and listening to their testimony in Douglas, I immediately decided that the clerks were right, that we needed to work on providing proof of residency in the registration process, which is in rule and has always been in rule. And I know the county clerks had also had discussions with the previous 2 administrations ago concerning providing proof of residency. So I immediately got to working on it. I know many of you were at the lunch we had at Arby's there in Douglas afterwards, and started talking to Clerk Irvin about addressing this. And then we convened a wave of meetings on this. The first was September 15th, which included a draft circulated by our office for comment. The second meeting was at the county clerk's breakout at the Association of County Commissioners meeting on September 28th. The third meeting was on October 20th, and the fourth meeting was on November 16th. And in between those meetings, there were extensive email exchanges between the County Clerks Association and the Secretary of State's office. So we worked with the county clerks on addressing proof of residency at the time of registration. We also notified the committee of this in your October meeting in our presentation. And so again, these are two entirely distinct things. Proof of bona fide residency versus creating a durational aspect to the attestation that is made at the time of registration. Very different. And so, again, I stand in total support of Wyoming adopting a durational residency requirement. I believe it is a necessary part of strengthening our residency requirements, and appreciate the committee. Thank you.
Thank you, Mr. Secretary. Committee, any questions? Representative Haroldson.
Thank you, Mr. Chairman. Just a real quick, just to clarify, you guys were talking about on page 4, line 9 through 14, that would be a strike, correct? And then on page 7, basically, at the end, we would put a effective July 1st conversation. Am I correct in what I picked up in your guys' testimony?
Go ahead.
Mr. Chairman, Representative Haroldson, yeah, it's section 2 on page 7, make it effective July 1st, 2024, not effective immediately.
Mr. Chairman.
Yes. Mr. Wiley.
Thank you, Mr. Chairman. And for either one of you. So the conversation we had about lines 9 through 14 were so, if somebody had moved into the state, they could still, be ensured that they could vote for, the presidency either way, determining these days. So how do you figure that we still make sure that we allow people to be able to vote in a federal election? Presidential election.
Well, thank you, Mr. Chairman, and appreciate delving into this. Mr. Rubino, do you want to take that and the history on that? Thank you.
Absolutely. Mr. Chairman, Representative Wiley, yeah, if I could walk through that, and I walked through this a little bit during the interim, mostly at our Douglas meeting, but also at our October meeting, and I know it had been flagged. It got us thinking about it from a couple of different angles. First, you have from examining more closely, the Voting Rights Act. And I think it was brought up subsection C of the Voting Rights Act on registration and imposing residency requirements. And so we delve deeper into the requirements of the Voting Rights Act, specifically subsection E. And if you'll allow me, I can read that. It discusses, and I think it ferrets out a little bit more, that was later addressed when they upheld the amendments to the Voting Rights Act in a 1970 case. And then, of course, there was a 1972 Supreme Court case. But the first one, the one that I'll talk about, is Oregon v. Mitchell. Specifically, it was discussed, this issue was discussed in concurrence by Justice Stewart, but the language of the Voting Rights Act, specifically 52 USC 10502 subsection E, provides, if any citizen of the United States who is otherwise qualified to vote in any state or political subdivision in any election for president and vice president has begun residence in such state or political subdivision after the 30th day next preceding such election, and for that reason does not satisfy the registration requirements of such state or political subdivision, he shall be allowed to vote for the choice of electors for president and vice president, or for president and vice president in such election, one in person in the state or political subdivision in which he resided immediately prior to his removal, if he had satisfied, as of the date of his change of residence, the requirements to vote in that state or political subdivision, or two, by absentee ballot in the state or political subdivision in which he resided immediately prior to his removal if he satisfies, but for his non-resident status and the reason for his absence, the requirements for absentee voting. If I can go into a little bit of the concurrence there where this issue was directly addressed by the Supreme Court by Justice Stewart, he talked about subsection E and squaring that with subsection C. And he stated in part in his concurrence, Section 202 added by the Voting Rights Act amendments of 1970 is a comprehensive provision aimed at ensuring that a citizen will not be deprived of the opportunity to vote for the offices of president and vice president because of a change of residence. Those who had taken up a new residence more than 30 days before a presidential election are guaranteed the right to register and vote in the state to which they have moved, notwithstanding any durational residency requirement imposed by state law, provided, of course, that they are otherwise qualified to vote. And this is where it gets to the operative language. Those who take up a new residence less than 30 days before a presidential election, so say our presidential election was November 7th, and you moved there in October, end of October, so you're within that 30-day time frame, either are guaranteed the right to vote either in person or by absentee ballot in the state from which they have moved, provided they have satisfied as of the date of their change of residence the requirements to vote in that state. And so I think getting at that and reconciling that, those two subsections, it's where is the onus of allowing you to vote for president and vice president? I would submit that after reading just the language of the Voting Rights Act and that concurrence, which the thing that I found that actually fleshed it out, it's the state from which you've moved, not the state that you're moving to in that 30-day window, right? If it's outside the 30-day window, it's different. But then if you have a 30-day durational residency requirement, it doesn't matter. Wyoming's addressed this in Wyoming statute 22-1-102, subsection A, Romanet 30, dealing with our residency requirements and our sort of principles of dealing with residency by saying in subsection, not subsection, capital E, if a person removes to another state with the intent of making it his residence, he loses his residence in Wyoming, except that in a general election year, if his registration is valid in Wyoming when he leaves this state and he is unable to qualify under the laws of his new state of residence to vote at the primary or general election, he shall be deemed to have retained his residence in Wyoming for purposes of voting by absentee ballot in the primary or general election. So just on the other side of it, if you move to Idaho, that's a great example because this is what ours mirrored. And you moved there within 30 days, you didn't satisfy their durational residency requirement, Wyoming would be obligated under state statute and the Voting Rights Act to allow you to vote all the way down the ballot. But other states, it's a little different. Some specify that it's only for president, vice president, and so I think it's the way that states have dealt with that. I just think that the onus is on the state you've moved from. And I think that the language on page 4, lines 9 through 14 is, I don't think it's necessary to the bill.
Mr. Chairman, Paul.
Yes, Representative Wiley.
Thank you, Mr. Rubino. So just, I appreciate the technical explanation and everything. So just so, you know, the few concerns that we had and for the folks at home, Wyoming will not impede anybody's ability to vote for a presidential election. The answer is no, correct?
Mr. Urbino?
Thank you, Mr. Chairman. Representative Wiley. Yeah, I think that it's getting at the onus is on the state that they moved from.
So, Mr. Chairman, you know, I wanted to add a couple things, okay, if I had a couple
Mr.
things, and
Secretary.
I'm responding to that as well. I mean, we reached out to Idaho, which this is mirrored off of, and they also have an NVRA exemption, so they're very similar. And we asked if they conduct different elections based on president and vice president, whereby new registrants who do not meet the 30-day residency requirement will not be prevented from voting for president and vice president. And in response, the person there we talked to noted that Idaho does not have different registration standards for state elections than those for president and vice president. Bottom line, if you don't meet it, there's one ballot, and so, you know, that's the restriction. So Idaho's 30-day residency requirement to vote applies regardless of election type, which would be the original bill before it was amended in October. And then we further asked an example. If someone had barely moved to Idaho, say 15 days before an election, and they wanted to vote there, they would be told by Idaho election officials that they could vote in their previous jurisdiction since they had not met the 30-day residency requirement.
Follow up?
Thank you.
All right. Any other comments? Okay, if not, is there any, I don't see any, but is there any legislature in the room that has questions? If not, let's move to public comment. Is anybody in the room here for this bill? And please state your name and for the record.
Mr. Chairman, thank you. My name is Malcolm Irvin. I'm the Platte County Clerk and the President of the County Clerks Association. With me is Mary Langford. She represents our organization. And we wanted to talk to you about this bill, and first off, just say thank you for all of your work in the interim and really listening to what we had to say, not just on this, but all pieces of legislation you considered. Mr. Chairman, on the bill, with the exception of lines 9 through 14 on page 4, not a lot changes for us, just to be frank. We would register people the same way, and to the Secretary's point, the enforcement mechanism for residency and the oath really would not change under this bill. On page 4, lines 9 through 14, I'm thankful that we don't have to get into the discussion as clerks about whether this is good or bad policy. But what we can tell you from the administrative point of view is there will be some difficulty with the actual registration process. And the secretary alluded to it, which is when somebody presents, they don't meet the qualifications for the 30-day residency requirement, but with this section would still get a presidential ballot. What we will have to do is still perform HAVA check or Help America Vote Act to ensure they're not a felon, they're of age, the person they're representing or purporting to be is alive. That's always important. And so, Mr. Chairman, what we have to do then is somehow verify through WildReg, the state's voter registration system, that those things are true. And there are some complications with that. And so if this were to pass with this section, we would really have to put some serious brain power as to how we would administer this. And to be clear on the amendment that the secretary proposed about the effective date, we would support that, a July 1 effective date. That makes sure that our May municipal elections are administered one way and there's not an interruption this early. But just to be clear that if this went into effect July 1 with this language, we would have a lift, to be honest with you, between July 1 and the primary in August. And so, Mr. Chairman, we would be happy to answer any questions you may have.
Yes, Representative Haroldson.
Thank you, Mr. Chairman. Mr. Irving, thank you for coming today. Mary, thank you. So you're saying that if you took out 9 through 14, that would be easier on you guys, because at that point it is simply, you need to go back to your state of residency prior to us. That is what that's your testimony, correct?
Mr. Chairman, and I appreciate that clarification. Administratively, yes, it is easier. Emotionally, it is less simple. Just to be clear, and I know the question wasn't directed to us, but somewhat in response to Representative Wiley's question, we're the ones that will be fielding that complaint and concern on election day, ourselves and our election judges. When somebody comes in and says, hey, it's on election day, I've lived here for 25 days or 1 day or whatever it may be, less than 30. I want to vote for president. I don't care about anything else on the ballot. And if that's removed, we will turn them away, obviously. And I just want that to be clear that we're the ones that will be bearing that confrontation on election day. So administratively, from the voter registration aspect, the creation of a separate ballot, sure, the administration of it would be easier. The emotion of it would still exist.
Follow up? Any other questions? Yes, Representative.
Thank you, Mr. Chairman. Hi. So if that happened with somebody that's 25 days, they would have to register either previously or on that day, is that correct?
Mr. Chairman, Representative Ottman, if this bill were to pass, and let's just theorize without that section about the presidential ballot, if this were to pass, we would not be able to register them because they hadn't resided in the state for 30 days preceding that election. So we would not be able to register them, we would turn them away. If this section is in there, we would have, and register them is not the right term, but we would have to have some mechanism to verify they're not a felon and all of the other requirements except the residency portion, the durational aspect. And then we would give them just a presidential ballot. I hope that answers.
Follow up.
Yes, I'm just wondering, wouldn't they at some point talk to the clerks and say, I want to register, and they'd be told this? I mean, isn't there voter information out for people to where they would see this?
Mr. Chairman, Representative Ottman, our position is always, we love it when people do come to seek the information from the clerk's office, absolutely. The reality of it is not every registered or potentially registered voter is coming to our offices. Would there have to be some voter education campaign on this? Absolutely. It's similar to the period in which changes to party affiliation. That's a new change for 2024. We'll undergo that this spring. And so we will do our best, but respectfully, it won't reach every potential voter.
Representative Ottman, follow up. Any other questions? No? Mary, did you have any comments or testimony you'd like to give before we?
Mr. Chairman, committee members, I'm Mary Langford. I fully agree with Clerk Irvin. There's going to be, if we leave the presidential portion in, and again, that's an emotional question. And the question is, I walk into the polling place at 6:30 on Election Day, and I just moved here from Hawaii 2 weeks ago. How do I vote? If the presidential piece is gone, I don't get to vote for president. That's the picture. There's going to be a cost to do the presidential part, because again, we have to run some sort of a pending registration or something to check and make sure that these guys are qualified to be able to vote. We don't want felons voting in our president election. And there's a cost that will be associated also with setting up that kind of a system, as well as producing those extra ballots, because you won't get a regular ballot. You'll get a ballot that's got a president and a vice president on it, and that's it. So, and the tabulation of those ballots, plus the fact that there's always a chance that you may only have one of those ballots, and then you have to worry about a secret ballot. So there's a lot to be thought about as far as generating that part of the election. But it's the question of whether you're going to tell someone, no, you don't get to vote for the president, and then, or if we're going to do that, then we're going to have to figure out how we're going to proceed with that. So.
Ms. Langford, I'm just curious, has there been any discussion with the clerks of a uniform way to address that? Has there been any discussions at all, or is everybody waiting to see?
Mr. Chairman, we have had discussions, and really through that discussion realized that if that section remains, there's a lift. So we do have some ideas how we would administer it. It's going to take a lot of really close coordination with the Secretary of State's office and with our individual offices to make sure that that portion is administered uniformly with such a tight time frame. But we have had discussions about it. Can I say we're concrete on an approach? No, partially because just waiting to see what happens.
Okay, thank you. Any other questions by the committee? Okay, thank you very much.
Thank you.
Is there anyone else in the audience that wishes to speak to this, public or agency? Come on up and introduce yourself.
Thank you, Mr. Chairman. Brett Moline, Wyoming Farm Bureau Federation. I believe this is the first time in front of this committee for this session. Anyway, representing my members, this is our policy that a 30-day residency should be required for somebody to vote for in a Wyoming election. Trying to be brief. I know you got a lot of work to do. I would take any questions you or the committee may have, sir.
Questions? Okay, thank you very much.
Thank you.
All right, is there anybody online? Oh, is there one more person that would like to speak? Hi. Please come up and introduce yourself.
Gail Simmons, Civics 307. I'm fine. I am neutral on the 30 days, but I do want to point out again that we keep using bona fide as if that was defined anywhere, and it's not. But that should not be a barrier to this legislation. What I do want to point out is that we must keep the pledge, the importance of individuals' right to vote. And so even if it's a heavy lift, even if it is causes some difficulties, what we cannot do is have United States citizens, simply because of a time in which they move, not be allowed to at least vote for president and vice president. So having the discussions, Mr. Chair, whichever one you are, having the discussion about it being the other state or our state, I don't care. I care about that voter who has a fundamental right to vote. And so we need to make sure that we're clear on that. So I am going to take this time to plug that if you pass this, if it's going through, then please make sure you are in support of third reading Amendment 69 that puts $95,000 to the county clerks for voter education, because the truth is, there is very little. They don't have the funds or the resources to provide the kind of education that's needed. And there are a lot of moving parts from 2022 elections to 2024, including 19,000 people who are no longer registered, who were registered in 2022. So go ahead and pass this. Please keep the ability to vote for president and vice president, but also make sure that you're keeping this in mind when you're looking at the budget. And I stand for questions.
Thank you. Any questions? Okay, seeing none, thank you for your testimony.
Thank you, Mr. Chairman and committee. My name is Marguerite Herman. I'm here for the League of Women Voters, and you may have heard from some of our members over the evening and this morning. We oppose this bill, which seems to be set up requirements simply for their own sake. It increases confidence, but it doesn't really actually fundamentally increase the security, integrity of the election system in Wyoming, which our county clerks conduct at just to the highest level, a degree of caution, but also making the polls available to all qualified electors. And just aside from the practical mechanics of allowing new people to the state to exercise their franchise to vote for president and vice president, I'll just run through some. Just looking at this proposal, what I see as problematic, that the 30-day limit, 30-day, it doesn't seem to come from anywhere on any basis. 15, 45 days, 30 days is sort of seem to be kind of arbitrary, and then 30 bona fide days. How do you qualify a bona fide day? And that I was staying with my cousin for 15 days, and then I got apart. I mean, it's the time lapse doesn't seem to have any real basis. And I'll just say, we never have in the interim or now heard a report that someone who was here for less than 30 days, that was somehow kind of a sign that they were knowledgeable or were intent to really stay in Wyoming. And we didn't really hear any stories about why 30 days, why people who are new to Wyoming, they lack the bona fides to cast a vote. Let me see, we talked about the president, vice president, the federal access. There's no way to assure that a voter spent the last 30 days in a bona fide manner. It's just a time lapse. This creates a requirement for county clerks to enforce with no means to investigate and verify that the signed oath is correct. The bill restricts a group of people and excludes them from the ballot box without justification. The requirement fences out from the franchise a fundamental constitutional right, a sector of people simply because they're newcomers. And I would just say, just the overall thought that the league has is that, yes, there are reasons to restrict access to the ballot, restrict voter registration, to purge and require people to re-register. Those all have valid things. But whatever restriction that is imposed should have a corresponding benefit to the process of and the integrity and the safety of our elections. And that this proposal lacks that verification, I think. That the league believes that the franchise should be as broad as possible while it is safe and secure and have integrity. And so in that tension between the two, I think this fails that test. So I would just encourage you not to forward this again, it just seems to not be justified by whatever restrictions would be imposed. And if you do it, if you do pass it, I really also encourage whatever others said is to accommodate the new person to preserve their right to participate in federal elections. Thank you.
Committee, are there any questions? All right,
Thank you, Mr.
Thank you for your
Chairman.
testimony.
Thank you.
All right, will you please introduce yourself?
Hello. Excuse me. Hello, my name's Antonio Serrano. Mr. Chairman, I'm the Advocacy Director for the ACLU of Wyoming, and we are here today in opposition of this bill. So why do people come to Wyoming? Why do people want to make Wyoming their home? I feel it's because of the opportunities that they find here, and people want an opportunity to work hard and have a place to raise their families. It's a place where almost any one of us can drive 20 or 30 miles and take our families fishing and hiking. Some people come to Wyoming for safe schools and for safe communities, which I think we all appreciate and love. People want to be Wyomingites so that they can experience all the things that we love about our state. Nobody is moving to Wyoming to sabotage or destroy it. People just want to be part of Wyoming, and this bill denies equal representation for new Wyomingites. Having fair and equal representation is a cornerstone of American democracy. Every citizen should have equal access to the ballot box to choose those representatives who fight for their issues and policies that they care about. Having equal access to voting is a civil right that is recognized and protected by the Constitution. The Constitution requires states to apportion their congressional and state and local electoral districts according to the one person, one vote principle, and state legislatures have an obligation to ensure fair and equal representation for all people. HB 38 attempts to fix a problem that does not exist and is frankly a waste of time and resources. We urge you to vote no. Thank you for your time, and I stand for any questions.
Any questions from the committee?
Thank you.
Seeing none, thank you for your testimony. Is there anybody else in the room from the public that wishes to testify? Yes, sir. Welcome. Please identify yourself. Oh, is your mic on too there? Just press.
It's green. Does that mean I'm on?
There you go. We can hear you now.
I'll get a little closer. Sorry. Thank you all. And sorry, I just made the trip from Pinedale this morning on snowy roads, so I'll be quick. Sorry, I was running in late. This was one of the bills that I wanted to speak on. I'm a member of the County Attorneys Association, but I am not speaking on behalf of the County Attorneys Association. We didn't get a chance to discuss this bill. It sounds like this may have been brought up before. I was catching the tail end of the young lady's testimony earlier, and I think she touched on it a little bit. Looking at it from the enforcement perspective, it creates a significant issue with the question of what is a bona fide resident. Are we looking at something similar to how we look at residents for game and fish? What is that? And then when people are signing this, they're potentially subjecting themselves to a forgery charge, which ends up being a felony under Wyoming statute. I'm just speaking to the enforcement issues and would seek clarification on what you all mean and what the statute means on bona fide resident. What is that? How do we know from the prosecutor's perspective, if we need to proceed, how do we do it? So that's all I have, unless you have any questions for me.
Thank you. Any questions from committee? Representative Harshman.
Mr. Chairman, thank you for driving over from Pinedale today, for being here. You know, this bona fide thing is already in statute though, and it's in this part of the statute. So I agree. Do you have any suggestions for us? I mean, the word bona fide is on page 3, you know, Roman 6:26, page 3, line 8. Existing statute.
And
that right? I
can
mean,
you draw
that's
my
a-
attention to that?
I'm sorry, page 3 on line 8.
This is in the bill draft.
Yes, sir. Yeah, and it's in that 22-1-102 and the definitions. Qualified elector is the definition in paragraph 26. And it said includes every citizen of the United States who is a bona fide resident of Wyoming. That's existing, so I'm wondering, you know, if we need to clean that up or what do we need to do? So
And I
thank you.
guess, and I don't
Work
mean
through
to,
the chair there if you would.
Nope,
Yeah.
if you could.
Go ahead.
Mr. Chairman and Representative Harshman, to that point, let me clarify a little bit more of the concern. not necessarily on bona fide, because I hear you on that. But the question then becomes is what do we do on the 30 days? How do we do that? So how do we police that? When did they move? Was it the point in time when they got their Wyoming driver's license? Was it at the point in time that they abandoned all domicile in any other states, similar to how we work with Game and Fish? That's the question, and that's the rub, what I mean. And thank you for that clarifying question.
All right, any other questions? Okay, thank you very much, and thank you for coming all that way to testify too.
Thank you all. Have a good day.
All right, anybody else in the room on this issue? I do think we have somebody online. Julie Freese, Fremont County Clerk.
She has not raised her hand to speak.
Yes, please, go ahead and admit her. Yes, she. Julie, can you hear us?
Can you hear me?
Yes. All right, go ahead with your testimony and then we'll follow up with questions.
Good morning, and I'm sorry I couldn't be with you there today. I really don't have anything to add to what our president and our and Mary had added to everything this morning. I think the questions about the what to do if we do have to allow presidential ballots is the big question for us that we've been talking about recently. And I know you asked about uniformity for how we would all do that. And some of us are on e-poll books, the state e-poll book, where I can check every voter to make sure they qualify for the election, but not everybody is on that. And so our president is right. You know, we'd have to find some way else for other counties. Is that a call in and we have the Election Central run that information through the system so that we can give them an answer back, which always stops the line. But of course, we're going to have to do that at that point. You want to make sure only the people that are qualified vote. The last gentleman who spoke about the 30-day thing, that's a very real thing. I really hadn't thought about that. And I know in my county, we've gone through a lot of potential prosecution of folks of a number of different reasons. And that's a very interesting question of when that 30 days starts. So that's the only thing I would say about that. We can administer this as far as the registration oath as mentioned by the secretary. If they'll read the oath that says, you know, I've lived here for 30 days, then if for some reason they're challenged and they're found to be not innocent in that, that's where that all comes, you know, to fruition. So I don't have anything else unless you have questions for me. Thank you.
All right, committee, any questions? No, thank you for participating.
Thank you.
All right, anybody else online? Okay, I will close public comment. And what is the committee's pleasure? Move the bill, moved by Haroldson. Is there a second? Representative Ottman, second. All right, any comments from the committee? Should we go through the bill? Any changes on page 1? Yes, Representative Newsom.
If we are contemplating taking out that provision on page 4 in the enacting in the title, it has providing for an exception of electors otherwise qualified to vote for president, vice president. So would we take that out? Are we allowed to take that out? Maybe Chairman Harshman might have some insight on when we're creating an amendment that is non-conforming. Thank you.
Representative Harshman.
I think you probably could get the lawyers fired up here and see what.
All right. Well, that'll be a question, absolutely, going forward. But are there any changes on page 1? Any amendments? Page 2? Page 3? Representative Haroldson.
I will bring an amendment to strike 9 through 14, and if I get a second, we can have a conversation and just, because I think we need to have a conversation of what policy we want to decide on.
And that's on page 4.
That is on page 4. 9
Mr.
through
Chair-
14.
Any other on page 3 before we move to 4? Okay, page 4. Representative Wiley.
Yes, Mr. Chairman, I have a question. So if we remove this language,
We need a second.
okay,
Oh, I'm sorry. Do we have a second? You offered that as an amendment
Offered
for
it as an
changing,
amendment.
striking lines 9 through 14. Is there a second? Second? Okay, Representative Ottman. Okay, discussion on that.
Mr. Chairman.
Yes, Representative Wiley.
Okay, my concern is if we remove this language, we are going to make the choice for folks that may have not got any notice about a federal election, not even Wyoming election's a federal election. And you know, it's kind of our God-given right to be able to vote in this country. And I feel very strongly about that, especially as a Wyomingite. I understand what we're doing with the bill. I am in support of the bill. But if we remove language to where we're gonna step in the way of somebody to be able to cast that vote, I don't feel comfortable with this amendment. And it would be different, you know, I was looking at it, maybe we put a mechanism in there to advertise or something, you know, 30 days before, but I don't think it's germane to the title. So unless we can fix that, I can't support removing this language.
Okay, thank you. Any other comments? Representative Haroldson.
Thank you, Mr. Chairman. And at the end of the day, I think you're absolutely right. This is a conversation of on which side are we wanting to do this. Obviously, other states with the 38-day residency requirement are referring people back to the state they came from, which would work in a lot of situations. Might not work in other situations. I understand that could become cumbersome for the individual. So really, it comes down to a policy decision we have to make of, do we push our clerks to make another ballot to just for a president, vice president, and do that? Or from what we heard from Mr. Rubino, that it is covered under that act, that it's basically, it sits or sits on the shoulders of the prior state. So, I mean, I think we're in good standing if we do this, but again, it's a policy decision we need to make and what we want to do. So that's why I think it's just good to have the conversation moving forward and see where we go with that.
Thank you, Representative Haroldson. I would agree that it is a policy issue and certainly would elicit comments from the other members. Does anybody else have a comment on that? No? All right. We have a motion to remove or to strike lines 9 through 14 in a second. All those in favor, please say aye.
Aye.
All those opposed? No. All right, motion fails. Any other amendments on page 4? None? Okay, page 5. Page 6. Page 7.
Mr. Chairman. I would like to make the motion for the change that the Secretary of State's office wanted with the date here. Correct.
Is there a second? Okay, it's been moved by Representative Wiley, seconded by Representative Haroldson to change the effective date and clarify what that would be.
Yeah, I believe it was July 1st. July 1st.
Okay. July 1st, 2024. Is there any discussion? Discussion? Seeing none, all those in favor signify by saying aye. Aye. All those opposed? Motion carries. Okay. Back to the bill. Question having been called, Please poll the board. On House Bill 38.
Okay. Representative Chadwick? Aye. Representative Haroldson?
Aye.
Representative Harshman? Aye. Chairman Knapp?
Aye.
Representative Newsom? Aye. Representative Ottman?
Aye.
Representative Wiley?
Aye.
Representative Yin has submitted an absentee vote of no, and Chairman Olson has submitted an absentee vote of aye, making it 8 ayes and 1 no.
House Bill 38 has passed the committee. Next bill up is House Bill 89, County Clerk's Frivolous Filings Procedure. Welcome, Representative Larson. Please introduce yourself and
Thank you, Mr. Chairman. Glad to be here. For those out in the world, my name's Lloyd Larson. I'm in the House of Representatives and serve House District 54. And I have a bill here today, House Bill 89, Mr. Chairman, which is regarding frivolous filings that are starting to become a more common thing that our county clerks and particularly our judicial system is having to deal with, and we're trying to figure out a way to address such a thing. Currently in 29-1601, if there's a claim of a lien, Corporations Committee understands the lien part of this. If there's a lien against a federal, state, or local official or an employee based on their performance or non-performance, it's invalid unless a court of competent jurisdiction allows it, okay? But if there's a filing, not a lien, but just a filing that comes to the clerk, if I come to you, Mr. Clerk Chadwick, and I make this filing that I want filed in the county, you as a clerk take my check, then it's filed. And it's kind of there. And what we're seeing is that we have public officials that some may disagree with, don't like what they've done or don't like what they've said, and now are coming back, they can't do a lien, but they're filing a frivolous, they're making frivolous filings. I seen one on a circuit court judge where they were filing a claim for 20 some odd $1 million. There's no lien, but they were saying because of all the duress, and it appeared before the judge in a court and didn't like the outcome or didn't like the things, and so he makes this filing, and I think it can certainly lead to intimidation or cause a problem for your county commissioner or a clerk or anything else. And so what this bill does is makes an attempt to try to remedy that or give a provision to remedy it. And what we do, and we're going to do it in two ways. One is before the filing's taken place, and one is if a filing has taken place, kind of before and after. And so what we do on page 2 of the bill is we have the definitions of what a filing is, and it's important to understand what frivolous means lacking an arguable basis in law or in fact being presented by any improper purpose, including harassment. Okay, so we define that. Then we say that a county clerk, again, if I'm that individual and I bring this filing to the clerk, and the clerk says, I just don't think that has any basis. The clerk can determine that the filing may be frivolous, and he can decline, or she can decline to file it and tell the person, don't give me your check, don't want it, I'm not going to file this. And then the clerk declines, and to hold or holds in abeyance, the clerk then can file a motion with the district court in the county for that order, that the filing is frivolous, and the person seeking to make the filing will be given notice and have their ability to appear before the judge and say why that filing is valid and should be considered and indeed filed. The court then determines that the filing is frivolous. He can order that, he'll make an order declaring that, after which the clerk can then reject the filing. And the clerk shall refund, and so can refund the fee collected from the person seeking to file. So I had that wrong. You can take the fee, but if it's in abeyance, then they refund it within 10 days. My clerk, whom you heard from back home, said they probably just wouldn't take the check or would hold off, but they can't deposit it. They have to hold it. No filing shall be rejected unless, if they've deposited the fee. That's in 4. Then if a filing's already taken place and a clerk wants to notate that they think that it was frivolous, it happened in the past, the same thing happens. They send a notice to the person that made the filing, notifies them that there's going to be a hearing. The judge will hear it. If they make the decision that it is a frivolous filing, they can't remove the filing. Once it's filed, but they can put a notation with the filing saying that it's been deemed frivolous. Now, Mr. Chairman, there's an amendment. And you might have the proposed amendment here, that one of the concerns we had is we want to make sure that the courts respond in a timely manner. And so in both instances, and I would just make the recommendation that on page 3, after line 2, after the Roman 3, we start that section that says the district court shall act on the motion filed under paragraph 2 of this subsection not later than 20 days after the clerk files the motion. So it makes the court be responsive. And then we'll do the same thing on page 4 on line 5 after 3, put the same language in there. So on both cases, the person who's made the filing and the clerk aren't wondering what's happening for an undue period of time. The time of 20 days was a recommendation from the judges in my part of the world. I asked what a reasonable period of time was, and they thought that was appropriate. So, Mr. Chairman, I'm happy to answer any questions on that, on the intent of this bill or what the bill does.
Thank you, Representative. Any questions? Representative Harrelson.
Thank you very much, Mr. Chairman. Mr. Larson, so as I read this bill, I just started doing a little bit of research because it was something I'd never even really heard about. And obviously liens I'd heard about, but not just the filings. And so do you think this empowers clerks to engage in unauthorized practices of law? I mean, talk about that. Do you think this, I mean, it's putting something on, and maybe this would be a question for the clerks, because I'm trying to figure out, then obviously they're at a point where they're having to decide for themselves where they feel they stand on this. And I'm just wondering what that looks like.
Mr. Chairman.
Representative Larson.
Thank you, Mr. Chairman, and Representative Harrelson. That's indeed why the courts are involved. My first swath at that is, well, can't the clerks just, this elected official, but then we're empowering them to make a decision that could be influenced pro, con, or otherwise in an appropriate way. So in their duties as elected official, they have to make some decisions anyway, right, that I think we all recognize. So them making a decision that they think that the filing is frivolous is the limit of which they can go. That's why we then involve the judicial system, whose job, and we move that out, and that's what we have in there for, is to review by point, and that's why the definition of frivolous is there, is because it just isn't sustained by law, and let the judge make that make that decision and allow the person making the filing to plead his case or her case to the judge as well, where that probably would just end up in an argument in the county court clerk's office, right? If they had that. So that is my attempt to make sure that we, first off, don't put the clerks in a bad spot to where we're forcing, because I don't think they want to make those decisions, but yet there has to be a mechanism there to address it. To your point, Mr. Chairman and Representative Harrelson, it's been in the last, my understanding, it's been in the last 5 to 10 years that we're really seeing some of these frivolous filings start to appear, and hence, here we are.
Any other questions? Representative Wiley.
Mr. Chairman, thank you. Mr. Co-Chair. So would you have to go down that entire legal process to have some kind of mechanism for an appeal on the designation of frivolous? Or can that be done prior to having to go all the way down through the courts? So if they, let me get at what I'm trying to say here, and it might not come across correctly. So if they designate your filing as frivolous and you don't agree with it, but you don't want to take it wholly to the court system, could you file some kind of an appeal or something to have that looked at again?
Mr. Chairman.
Representative.
Mr. Chairman, Representative Wiley, fair enough, and had contemplated that to some degree, but if I'm going to appeal it, who am I going to appeal it to, right? So hence, that's why we don't give, and alls we're allowing the courts to do is based on their professional understanding of what a clerk's requirements and obligations are, is to look at that and say, this just really appears frivolous. I could be wrong, right? But I think it is. And then the mechanism for making the determination leaves their jurisdiction and lies within the court. Now, if you disagree with the judge, then there's recourse, right?
Representative Ottman.
Thank you, Mr. Chairman. Mr. Co-Chairman. Okay, I'm not real familiar with the judicial system or with this, but what I would like to, I have a couple questions. First off, what kind of a filing are we talking about? Is there only one kind of filing that this could pertain to? And if not, what are the other ones? And I'd also like to know what is the possibility for this, or the nexus for it, I guess, is what I'm saying, because I haven't heard, it's just a filing for what? And frivolous, because if it's frivolous, it means it's of none effect or not important. So why would somebody file something that is not important? So I just need some clarification, thank you.
Representative.
Mr. Chairman, Representative Ottman, and it's important that we look at the definition of frivolous, because you're right. But per this statute, we're trying to define and help the clerks and the judge understand what frivolous means. And it means lacking an arguable basis in law or in fact being presented for an improper person, including harassment. So then where are we seeing this? We've seen it in several counties where individuals have been pulled over for a illegal driver's license or similar violation and refused to pay, so they end up in a court system. They come before the judge makes a ruling, they disagree with that, and then they come for a matter of redress or claim. They can't file a lien because we protect them on that. So then they come and they file a claim with the clerk and say, I'm claiming that Judge Ottman owes me $2,000, $20,000, $2 million because she's caused me to come over and take away from my livelihood. Now she's imposing that and she's wrong. She's a horrible judge to do that. And so I'm filing this, can't file a lien on property, but is making this filing. Is the filing substantiated? Does it have holding? That's the argument. And so to keep, but the clerk's required to file them. And so what claim, do they then have a claim against that judge, Judge Ottman, for that $2 million? Well, it would go to court or whatever, but there's got to be a basis for the filing. And so if the clerk of that county says, I just think that this is frivolous, then it would go before the judge to make the determination. The concern is that our elected officials and appointed judges are seeing an increase of these, and it certainly can come across as harassment, trying to intimidate.
Follow up, Representative Ottman.
Please, thank you for some of that clarification. As we go down through here, another couple questions. Number one, would this include FOIA? And number two, because that's Freedom of Information Act, and it says the clerk may, that the filing may be frivolous. So what kind of criteria is there on that? And then down as it goes through, may hold the filing in abeyance. And what I found, because I wasn't familiar with that, is that is being without or of waiting for owner or claimant, temporary halt. So a temporary halt, waiting for what? And if this would include FOIA, Freedom of Information Act says that anybody can file. So how is that going to be looked at? And one thing that I'm looking at is that as a citizenry, if there is a complaint, not to hold them to where they don't have recourse. If it has to go to court, if they have to get a lawyer to prove that they've been wronged, that can run into a lot of expense. And so I'm just kind of wondering if this is the best way to go about it. So if you want to answer some of that, I'd appreciate it.
Representative Larson.
Thank you, Mr. Chairman. And Representative Ottman, I think the question is fair on FOIA, but FOIA, any of those requests have a firm foundation in law and couldn't be. Again, we would want to say, per this definition of frivolous, meaning it's lacking an arguable basis in law. And FOIA those requests have a very firm foundation in law. So I would suggest that it doesn't impact FOIAs at all. To the next question regarding in abeyance, I think what we're trying to do there is the clerk takes I'm making this filing, and I give the clerk, I say I want to file, and they're saying, no, I'll take your check here, right? And I'm holding abeyance until we further decide. And that's as you come over into C. No clerk no filing shall be rejected, although that's if they've already deposited. So we talk about shall be given notice that determines the filing may be declined to file and may hold the filing in abeyance subject to this subsection. So then once, if it's determined that it is frivolous, they give them money back. If they've determined that it's not frivolous, they deposit the money and make the filing.
Follow up. Any other questions? So I just had one, Representative Larson, and I'm not an attorney, thank God. But to me, this kind of follows along what would be a civil suit. Because the clerk's not given absolute authority to say, this isn't going anywhere. It says, for any filing that the clerk declines to hold or to file or hold in abeyance, the clerk shall file a motion with the district court so that it gets kicked up to the district court to decide what is frivolous and what is not. And then that allows the clerk to reject the request. So to me, it's that foundation of laying whether a case is frivolous or not frivolous ruled by the district court. Is that not correct?
I'm not sure that I completely, Mr. Chairman, that I completely understood the point you're trying to make. I think I did, is we're trying to, where does a public official have the mechanism to address actions against them? And we really don't, to your point, don't really have the mechanism there to file a civil case. And so this does, in lieu of that, provide an opportunity for redress against a wrong.
Thank you. Any other questions? Is there anybody from an agency or the public that would like to speak on this issue? From the Clerks Association? Please come up and go ahead and identify yourself again.
Hey, how are you?
Mr. Chairman, thank you. My name is Malcolm Irvin. I'm the Platte County Clerk and President of the Clerks Association. Online is Julie Fries, the Fremont County Clerk. She'll be able to give you a lot more information about really the providence of this, this bill and this issue. We appreciate Representative Larson bringing this forward for the discussion to see what the potential solution may be. I can't say it's a new phenomena, but I can say it's becoming a more frequent phenomena where there are certain filings that are coming to our office that have some sort of allegation or some sort of statement on there, and mostly they're against public officials, judges, elected folks. And really the issue is they don't qualify as a lien because of that enforcement factor. They can't be foreclosed on, but they're really a statement. And they're going in the land records in our offices, and they're subject to public viewing, public scrutiny, and they're there forever, like your deed, like your mortgage. These are out there forever saying that that Judge so-and-so owes, and the providence of this issue was a claim that a judge owed almost $31 million in damages. And then it's in the property records in perpetuity. And so that could likely be a potential issue. Number one, just people going through chain of title and identifying that there's this claim out there, no merit to it, can't be foreclosed upon, but that issue exists. And then number two is that these can't be scrubbed from that record. They're there forever. There's no expungement. There's no sort of redaction. It's just there. And so, Mr. Chairman, that's really the genesis of this. And it is a complex issue that I think deserves a conversation and some discussion, because to Representative Haroldson's point, that our concern is that we don't want to be going through and examining every document. Some are just obvious on their face. When you have one similar to the one that really created this this discussion, a $31 million price tag after being adjudicated, that one was an obvious. Some may not be, and so our concern is going through those, and if a false one gets through or doesn't get through. So we share that concern that we would be reviewing documents. That's not what we want to do. Really, our important part is time stamping, date and time stamping. They're received here today at this time. But Mr. Chairman, I think there has to be a discussion about what the potential ramifications of these filings, and then what we do with them, if anything. So I appreciate that. And like I said, Clerk Fries is online. She would be able to offer a lot more information about this one in particular, but I'd be happy to answer any questions you may have.
Thank you. And we are running short on time, so I'll kind of limit testimony right now. But is there any questions for Clerk Irwin? No? Okay, thank you very much.
Thank you very much.
Anybody else in the room wishing to testify? Yeah, if there's multiple people, you can just all come up at the same time and one by one testify. Welcome again.
Thank you, Mr. Chairman. Again, my name is Clayton Malinkovich. I'm the Sublette County Attorney, again, not representing the County Attorneys Association. A couple of questions on this bill. As you all are aware, Wyoming is a race notice state. Essentially, that means the first person to the courthouse with a deed gets title of the property. what happens in this situation? And I guess I should be directing this question through the chairman, Mr. Chairman, to Representative Larson. How does the statute address that? What happens in that time period in the event that the clerk sees the recording of a deed, for example, in that time period, what if another deed comes in and is recorded? What happens in that space?
Representative Larson?
I think if a deed was used here, that would be considered a lien, would it not? Against the deed. When you refer to a deed, I think you're referring to property, and I could be wrong. But I don't think we're referring that there's a filing against a deed of any nature. It's just a filing laying claim. The lien part of this, Mr. Chairman, is taken care of in the other section where they already address that in statute.
Okay, so I just.
Mr. Malkovich?
Oh, and so, Mr. Chairman, Representative Larson, when we're talking about the filing, you're specifically excluding any and all conveyances? Okay. So then the question that does, and thank you for bringing that up, and that's, I appreciate you pointing that out. The other question that this does raise is it's creating a discretionary action for a clerk. Going to Representative Haroldson's question about that practice of law, are they in that situation where they're needing to make those decisions on frivolousness? Does that include errors in a notary stamp? Maybe the notary was expired, other things like that. And then the back end on that, because it is a discretionary action, although county clerks are immune from this type of a claim under the Wyoming Governmental Claims Act, it doesn't necessarily mean that they are immune under a 1983 claim in the event that they are negligent in their action here.
Representative Larson?
Thank you. And again, I would say that's why we take it to the level of having the courts review it. I think any elected official, whether it be a county attorney, a clerk, whatever, has to make some discretionary observations and judgments based on their understanding of the office. Nope, you can't have, you do not qualify for this property tax exclusion. Nope, this is the wrong date. I mean, we have, there's not just a specific checklist. They go down and says, no, according to this statute, no, that prevents them from making a decision, a discretionary decision in their office. That's why we elect them, and that's part of it. But, so, again, in this instance, we want to protect the clerk so that they're not being put in the position that they have to say, this filing, boom, pound, hit the gavel, is frivolous. They're saying it appears to be frivolous to the point that we think that it needs judicial review, and we'll let the judge do on that. If you disagree with me on that, you will have your opportunity to plead that in front of the court, just the legal process that we do, and removes the clerks out from having this ultimate authority of saying it is or it is not.
Okay, thank you.
Thank you, Representative.
I think that covers the questions that I had briefly on this. Thank you, Mr. Chairman and committee.
Thank you. Any questions from the committee for Mr. Malkovich?
I'm sorry.
Oh, I just asked if there's any questions, but there are none. Okay, so let's go to online real quick. Julie, do you have comments on this bill?
Sure. Julie Freeze, Fremont County Clerk. I don't think I did it before, sorry. So I just want to go through some procedures real quick here that might allay some of your fears. So the first thing, when county clerks get something to record, so remember, we're going to get something that's going to go in the recordings. These don't qualify for our UCC statutes as they are not titled vehicle type of things. So we put them in the recording statute, and you have to look for a grantor, grantee, a legal description, that there's a signature, and then it's acknowledged. Those are the general things of what our job is. So we don't typically go through our documents to try to determine if it's legal or not. That's not our our purview. I can tell you, I have 7 of this particular one that happened, 7 from this guy. They're all different, but you can tell from the very first page that these are frivolous filings. I have a 12-page document. 9 of the pages are how much money is owed for using of their trade name, using of their driver's license, using of their social security number, usage for time for his court appearance where he was picked up to and had to be in court. I mean, it's real obvious, and they're huge dollar amounts, huge dollar amounts. This was, as mentioned before, it was a $30,685,500 lien against these 2 people, a county attorney, person who was in the, or attorney who was in the court, and also the judge. We've had other people have filed things to denounce their citizenry of the United States. Those are things we file. I mean, record, actually. I should keep saying record. We record those. They don't have anything about anybody else. It's about themselves. They're different in nature. Freeman writs, we record. Usually does not go up against the sheriff or anybody else, but if it does, that's the kind of stuff we're looking for. It's action that they're saying about somebody else that could harm their reputation. It could harm, and what these 2 people, the attorney and the judge, were concerned was, what's next? My house? Then I won't be able to ever get a lien again. And so we know that part is covered, but these are definitely frivolous. I mean, this one in particular, all of these, the same one is filed also in Carbon County against their county attorney's office and their court judge as well. Again, we as clerks are not trying to do this just so that we don't have to. I mean, it's money to us. So, I mean, it used to be file and smile, but some of this stuff, when it's going up against public officials, which could be anybody, I think it's something we should look at. I also want to mention that in the procedure of this, if I believe it's frivolous against a public official, I'm going to go to my county attorney because I can't file a motion. I am not an attorney. So I was promised through the judge and Representative Larson, my job would be to go to my county attorney who's going to review it because he has to file the motion in court. So he is going to say, Julie, this, and I did this with this particular one, although I had no method to reject it. I went to my county attorney. And so I think there's a lot of worry about that we're going to just start rejecting all kinds of stuff. That isn't what we're here for. But I do believe when it comes up against a public elected official or appointed official, there are some concerns with that. And I'll take any questions that you have.
Clerk Freeze, thank you for your examples. Are there any questions from the committee? Quickly.
Thank you, Mr. Chairman. Clerk Freese, how are you?
Good, how are you?
Good, thank you. What I'm wondering is, since the bill primarily mentions filings and you're talking about recordings, is the bill user-friendly with the word filing? Or is it correct, I should say? Is it correct, not friendly?
Clerk Freeze.
Mr. Chairman, Representative Ottman, I did bring that up to Representative Larson. Filing and recording is used interchangeably. I have nowhere else to put it but in recordings, and so that's why we record them. So it might be user-friendly that way because I can't record it in UCC filings.
Thank you. Any other online public? Okay, I'm going to close testimony. And board, what is your?
Move the bill.
Okay.
Second.
Moved by Chadwick, seconded by Harshman. Is there any discussion? Is there any amendments?
Question?
No amendments?
You want an amendment?
Well, we did have discussion
those
on
two.
the 20 days language, and Representative Larson, if you can kind of reiterate that language to anybody who would like to make amendment.
So, thank you, Mr. Chairman, for the opportunity, and if you do that on page 3 and page 4, on lines 2 and on line 3, or line 5, after Roman 3, just start that sentence that says the district court shall act on the motion filed under under paragraph 2 of this subsection later in 20 days. So it's making the requirement for the judge to respond. And staff, I've got the language.
Okay, is there anybody who would like to make that amendment? Moved by Chadwick, seconded by Harshman. All those in favor say aye. Aye. All those opposed, no. Amendment carries. And you'll have the language for that. Okay. Any other amendments to the bill? Okay. Motion on the bill. We have before us Bill 89. Could you please pull the board?
Okay, Representative Chadwick? Representative Haroldson?
Aye.
Representative Harshman? Chairman Knapp?
Aye.
Representative Newsom? Representative Ottman?
Aye.
Representative Wiley?
Aye.
Representative Yin has submitted an absentee vote of aye. Chairman Olson has submitted an absentee vote of aye, making that 9 ayes do pass with amendments.
Thank you, Mr. Chairman, committee.
Thank you. House Bill 89 has passed the committee. Seeing no other business, committee is adjourned.